Imagine a scenario that honestly happens every single day now. You've got a troll sitting in a basement in New Jersey, and they write a devastating, completely fabricated lie about your professional conduct.
Right, a total nightmare scenario.
Exactly. And they post it on a forum that happens to be hosted on a server in Dublin, Ireland. Then, a few hours later, a potential client of yours who is sitting in Sydney, Australia, downloads that page. They read the lie, and they immediately cancel a $1 million contract you were about to sign in Mumbai, India.
Oh, wow, yeah. The damage is done
So
instantly.
you've ruined, your reputation is ruined, your business is severely damaged, so obviously you set a fight back. But where on earth do you actually sue? Do you sue in New Jersey, where the troll literally typed the words?
Yeah.
Or Ireland, where the data was stored? Maybe Australia, where it was read? Or, I don't know, India, where you actually lost the money?
And see, the scenario you just outlined, it's the ultimate nightmare for traditional legal systems. Because for centuries, the law was built strictly on physical geography. You knew exactly where your property line ended and where your neighbors began.
Right, like if someone throws a rock through your window, you know whose jurisdiction it is.
Exactly. The jurisdiction was obvious. But the internet took that neat geographical map of the law and just completely shredded it. I mean, we are looking at a space where the borders are not just invisible, they're constantly actively moving.
Well, welcome to our deep dive into the labyrinth of cyber law, privacy, and digital defamation. If you are joining us today, and yes, I mean, you, the one listening right now, you're
Okay.
clearly here to master the mechanics of this space.
And we have a lot to cover.
We really do. We're tackling a massive stack of source material today. We've got excerpts from Rahul Mathan's Privacy 3.0, Andrew Murray's really comprehensive work on defamation, a highly detailed scholarly paper by Malhotra and Malhotra on India's DPDP Act of 2023, and of course the foundational IT rules.
Right. And the mission today is not just to give you some high-level summary. If you're studying for an exam or needing this for a high-level professional application, you need the gears. You need to dismantle the legal machine and understand exactly why the law functions the way it does.
Yes, absolute clarity is the goal. We're focusing on the logic that judges and lawmakers actually use to solve these unprecedented digital problems. So, what's our roadmap looking like?
So we're going to move chronologically and thematically. We have to start with the philosophical and constitutional birth of privacy in India. Then we'll move to the UK to understand how the internet just shattered traditional defamation laws.
Oh, the defamation stuff is wild.
It really is. And from there, we'll explore intermediary liability, figuring out who to actually blame when the internet does damage. And finally, we'll return to India to dissect the modern statutory codes, like the DPDP Act, that try to govern our digital identities today.
Okay, let's unpack this. I want to start by looking at India first, because the evolution of privacy there is, well, it's fascinating. If we look at the United States Constitution, the concept of privacy is baked right into the text, right?
Yeah, the Fourth Amendment, it explicitly protects citizens against unreasonable searches and seizures.
Exactly. So
Yeah.
the architectural blueprint of the country clearly labels a room called privacy. But historically, if you read the Indian Constitution, the word privacy simply wasn't there. The blueprint was just completely silent.
And that silence created a profound legal vacuum because, the framers of the Indian Constitution were acutely aware of the U.S. Constitution. They studied it, yet they deliberately chose not to include an explicit privacy clause.
Really? It was a deliberate choice.
Yeah, and the early post-independence judges, who were strict originalists, they interpreted this omission quite literally. They believed that, well, if the framers had intended for privacy to be a fundamental right, they would have written it down in ink.
So it's basically like living in a house where you strongly suspect there should be a hidden room. But because it's not on the actual floor plan, the authorities just insist it doesn't exist.
That's a great analogy.
How does a legal system move from that absolute denial to recognizing privacy as a fundamental human right? Because it is one now.
It happens really slowly, mostly through a process of judicial friction. We can trace this evolution chronologically, and you should definitely note this down for your exam. It starts in 1954 with a case called M.P. Sharma v. Satish Chandra.
Okay, 1954. M.P. Sharma.
Right. This is the first recorded instance of the Supreme Court of India grappling with the concept. The government had basically conducted these massive, sweeping search and seizure operations against a prominent business group. And the business owners challenged this, arguing that seizing their private documents violated their right against self-incrimination.
So they were basically trying to use the Fifth Amendment argument from the U.S. that you can't be forced to provide evidence against yourself and tying it to the physical search of their offices?
Exactly. And the Supreme Court analyzed this and explicitly looked at the American framework. They noted the U.S. Fourth Amendment's protection against unreasonable searches, and then they made a very blunt observation. They said the Indian Constitution has no such equivalent.
Ouch. So they just shut it down.
Pretty much. The court ruled they couldn't magically read a privacy protection into the text. Now, it was just a throwaway remark, but it formally documented the absence of the right. It planted a seed of awareness that the Indian legal framework had a massive blind spot regarding state intrusion.
And that blind spot became a glaring crisis, 9 years later, in a really landmark case, Karak Singh v. State of UP. And the facts here are much more visceral than just corporate document seizures, right? We're talking about physical police surveillance.
Yeah, the facts of Karak Singh paint a really stark picture of state power. Karak Singh was a suspect who had been released due to a lack of evidence, but the police opened a history sheet on him and subjected him to intense surveillance.
What does that actually mean in practice?
It meant secret picketing outside his house, tracking all his movements, and most aggressively conducting what they called domiciliary visits at night. So police officers would literally knock on his door at 2 in the morning, wake his entire family just to check to see if he was home.
That is the literal definition of psychological harassment. I mean, he challenged this under Article 19, which is the right to free movement, and Article 21, the right to life and personal liberty, right?
He did. And the Supreme Court formed a 6-judge bench to decide the matter. And here is where it gets tricky for students. The majority opinion stuck rigidly to the originalist interpretation we saw in MP Sharma.
Wait, really? They upheld the harassment?
Well, they ruled that the unauthorized nighttime visits were illegal because they didn't have a backing statute. But the general surveillance and tracking of his movements, they said that did not violate the Constitution simply because privacy was not a guaranteed right. The majority effectively said, we sympathize, but our hands are tied by the text.
Wow. But the true legacy of Karak Singh isn't actually that majority ruling, is it? It's the minority dissent by Justice Subbarao. He was looking at the exact same text, but he interpreted the concept of liberty entirely differently.
Yes. And listen closely here, because this is a classic exam trap. Do not write that Karak Singh established privacy as a fundamental right. It absolutely did not. It was just a minority opinion by Justice Subbarao.
Right, underline that. Minority opinion.
But it was a brilliant, visionary dissent. He argued that it is impossible to sever privacy from personal liberty. He stated that the concept of life in Article 21 means more than mere animal existence. It means the right to live with dignity.
Right, because how can a person have liberty or dignity if the state can just stand outside their window and monitor their every move?
Exactly. He essentially argued that the right to privacy, while not explicitly written, is an essential invisible ingredient baked into the very definition of personal liberty.
He was trying to draw that hidden room onto the blueprint. But like you said, because he was in the minority, his opinion did not become the law. The originalist view held firm. The door stayed locked. Which brings us to the next massive clash, which is Govind v. State of Madhya Pradesh.
And Govind presents a fascinating mechanical puzzle for the judiciary. The facts were almost identical to Karak Singh. Police surveillance, history sheets, domiciliary visits. The petitioner again claimed this violated his fundamental rights.
So what was the puzzle?
The problem was the structure of the court. Govind was being heard by a 3-judge bench. Under the strict rules of precedent, a smaller bench cannot legally overrule the decision of a larger bench. And remember, Karak Singh was a 6-judge bench.
Oh, I see. So Justice K.K. Matthew, who was writing the opinion in Govind, was completely trapped. He had the 6-judge Karak Singh ruling staring him in the face, saying privacy isn't a fundamental right. How on earth do you rule in favor of a citizen's privacy without breaking the foundational rules of how the Supreme Court operates?
It's a great legal maneuver. Justice Matthew acknowledged the Karak Singh precedent, but he also recognized that society, technology, and international law had advanced significantly since then. He looked globally, specifically citing the U.S. Supreme Court decision in Wolf v. Colorado, which emphasized the security of one's privacy against arbitrary police intrusion.
So rather than attacking the Karak Singh ruling directly, he just sidesteps it by pointing to changing times and international norms.
Basically, yeah. He fundamentally shifted the narrative. He wrote that the right to privacy is implicit in the right to life and liberty. However, and this is key, he didn't make it absolute. He ruled that while privacy exists, the police surveillance in this specific case could actually continue.
Wait, what? After all that, the surveillance continued?
Yes, but only because Govind was a convicted criminal and the state had a compelling interest in public safety. But he warned that mere suspicion does not warrant such severe intrusion.
Okay, so he found a window into the room. He didn't overturn the old ruling, but he definitively stated that the right exists within Article 21, even if the state can sometimes override it for security reasons.
So when does this right finally step out of the shadows of just police surveillance and become a fully recognized constitutional shield for everyday life?
That transformation occurs in a dramatic case called R. Rajagopal v. State of Tamil Nadu. This one didn't involve the police knocking on doors. It involved a notorious serial killer known as Otto Shankar, who was actually on death row.
Oh, I've heard of this. He wrote an autobiography, didn't he?
Yes, he wrote an autobiography detailing his crimes, and more importantly, detailing the really close nexus between himself and several high-ranking police and prison officials.
And naturally, those officials did not want that book published. They claimed that publishing the book would be a massive invasion of their personal privacy. Exactly. And here, the court had to define the exact boundaries of the right to be let alone. Up until this point, privacy in India had largely been treated as a mere tort. A civil wrong. Like, if someone peered into your window, you could sue them for damages, but it wasn't a constitutional crisis.
Right, it was just a dispute between private parties.
But Rajagopal elevated privacy. The Supreme Court explicitly stated that the right to privacy has acquired constitutional status under Article 21. It is the fundamental right to safeguard the privacy of your own, your family, your marriage, and your education.
But the court ruled against the police officers trying to stop the book, didn't they?
They did. And the reasoning establishes the most important exception to privacy law. You need to know this for any exam. The court held that if a person voluntarily thrusts themselves into a public controversy, or if they are a public official acting in the discharge of their official duties, their threshold for privacy is significantly lowered.
Because the public has a right to know.
Right. The freedom of the press and the public's right to know about the conduct of government officials overrides the officials' desire to keep their corrupt dealings secret. You just cannot use the shield of privacy to hide public misconduct.
That makes perfect logical sense. So we've watched the legal machine slowly build this right from the ground up. It starts with the acknowledgement of its absence in MP Sharma, gets theorized in the Karak Singh dissent, quietly legitimized in Govind, and is finally codified into Article 21 in Rajagopal.
Yes, the foundation was finally poured, but then the courts faced a much harder task. They had to actually apply this abstract concept of privacy to the messy realities of human bodies, minds, and relationships.
Let's explore that, how this newly minted right is actually applied. And I want to emphasize to you listening, as we look at these landmark applications, we are focusing on the legal mechanics, how the courts balance competing rights. We'll stay totally neutral on the social context here. Let's start with the most intimate space imaginable, the physical body within a marriage. We see this in the case of T. Sarita v. Venkata Subbiah.
This case challenged a deeply entrenched concept in personal law, which is the restitution of conjugal rights. Essentially, the law allowed a court to order a spouse who had left the marital home to return and resume their marital duties, which, inherently includes sexual relations.
The idea that a court could legally mandate what a person does with their physical body seems like the ultimate violation of the right to be let alone.
The Andhra Pradesh High Court viewed it exactly that way. They leaned heavily on progressive international jurisprudence, specifically the U.S. Supreme Court decision regarding Planned Parenthood. The court established a vital principle. The right to privacy is not extinguished by the act of marriage.
So an individual does not surrender their bodily autonomy at the altar.
Precisely. The court ruled that forcing a woman to use her body against her free choice is the grossest form of violation of her dignity and her Article 21 rights. They struck the provision down as unconstitutional.
Okay, so in Sarita, privacy creates an absolute boundary around bodily autonomy. But the law abhors absolutes, right? Just when you think a rule is fixed, a case like Sharda v. Dharampal comes along and forces a complete reevaluation.
Sharda is perfect for exams because it illustrates what happens when two fundamental rights collide at high speed. So Dharampal filed for divorce, claiming his wife, Sharda, was of unsound mind. Now, in a court of law, you cannot just make a claim, you must prove it. So Dharampal asked the court to order Sharda to undergo a medical examination to prove her mental state.
And Sharda, relying on the exact logic we just saw in Sarita, says no. My body, my medical data, is my private domain. You cannot force me to undergo an invasive medical exam against my will. That's a brilliant legal defense.
It's very strong. But the Supreme Court had to zoom out and look at the broader implications here. On one side of the scale, you have Sharda's right to bodily privacy. But on the other side, you have Dharampal's right to life under Article 21.
Wait, how does a medical exam relate to his right to life?
The court reasoned that the right to life must mean the right to a healthy life. If Sharda was genuinely suffering from severe, incurable insanity, forcing Dharampal to remain legally bound to her would destroy his right to a healthy, fulfilling life.
Oh, wow. So how does a judge choose between Sharda's privacy and Dharampal's healthy life?
By applying the principle of proportionality, the court determined that a medical examination, while intrusive, is a temporary and relatively minor invasion of privacy compared to the permanent destruction of Dharampal's life if he were trapped in a marriage with a person of unsound mind without legal recourse. So the court ruled that Sharda's privacy had to yield to Dharampal's right to a healthy life. They ordered the exam.
That is such a critical distinction. Privacy is not a trump card that wins every single hand. It is always subject to a balancing test against the rights of others. And we see this exact same balancing act applied to DNA testing in the Bhapani Prasad case.
Right, because DNA testing takes the privacy invasion to a microscopic, fundamental level. The Supreme Court noted that a DNA test doesn't just reveal a person's current physical state. It reveals their genetic blueprint, their predispositions, and inherently compromises the privacy of any children involved.
So they set a much higher bar than just a regular medical exam.
Exactly. Building on the Sharda logic, the court established an incredibly high bar. They ruled that DNA tests must never be ordered routinely or casually in civil disputes. They can only be mandated in cases of what they called eminent need, where the truth cannot possibly be discovered by any other less intrusive means.
Okay, so the law protects the physical body and the genetic code. Let's work inward, to the mind. The 2010 case of Selvi v. State of Karnataka explores the absolute frontier of mental privacy.
Selvi is a monumental ruling for criminal jurisprudence. The state police wanted to use narco-analysis, polygraph tests, and brain mapping techniques on an accused individual. The state's argument was basically practical. These tools help us solve crimes and protect the public.
And the accused argued that this was a horrific violation of the right against self-incrimination and their right to privacy. What's fascinating here is the court's analysis of the mechanics of these tests. They didn't just look at the outcome, they looked at the process.
Precisely. The Supreme Court dissected how these tests actually work. They noted that narco-analysis involves injecting a person with drugs like sodium pentothal to artificially lower their inhibitions. Polygraphs and brain mapping require physical confinement, scrapping a person to machines, and bombarding them with stimuli.
It sounds like torture when you put it like that.
Legally, the court ruled that subjecting a person to these procedures without their explicit, informed consent is a massive intrusion into their mental privacy. You cannot artificially bypass a person's conscious will to extract information from their mind. It is a violation of human dignity and Article 21.
It essentially establishes that the inner workings of your consciousness are a fortress that the state cannot breach, even to solve a crime.
Okay, let's pivot from the biological to the financial. Because money is also private. We have a trio of cases dealing with how much the state can poke around in your bank accounts. Let's hit the Canara Bank case first.
So the District Registrar and Collector Hyderabad v. Canara Bank case dealt with a state law that gave a government official the power to authorize searches and access documents stored in a bank. The Supreme Court had to draw a line here.
Did they say the state can't look at bank records at all?
No, they reaffirmed that privacy protects against intrusive observation, but they acknowledged that the state needs powers of search and seizure to prevent fraud or collect taxes, but they instituted a strict threshold. These powers cannot be used for just fishing expeditions.
Meaning they can't just browse to see what they find.
Right. The state can only breach financial privacy if they can demonstrate a necessary state interest. There must be a specific, compelling reason, not just general curiosity. And we see the protection of reputation in the Venu v. State Bank of India case. This is a scenario a lot of people can probably relate to. Venu defaulted on a loan. The bank, frustrated with the lack of payment, decided to use public humiliation as a debt collection strategy. They threatened to publish his photograph, name, and address in major daily newspapers.
Yeah, naming and shaming. But the Kerala High Court intervened forcefully here. They delineated the bank's legal rights from its illegal tactics. The bank has every right to file a lawsuit, seize assets through the proper channels, and recover its money.
But they can't ruin him publicly to do it.
Exactly. The court ruled that destroying a citizen's public reputation is not a legally sanctioned method of debt recovery. Threatening to publish a defaulter's details is a gross invasion of privacy. The only legal circumstance where publication is allowed is if a formal court has declared the person a proclaimed offender or an absconder.
Good to know. The third financial case is massive in its scope, and that's Ram Jethmalani v. Union of India. This was driven by a huge public desire to uncover black money, untaxed, illegal wealth hidden in foreign bank accounts. Ram Jethmalani, who was a prominent lawyer, petitioned the Supreme Court to force the government to disclose the names and details of Indian citizens holding accounts in banks in Liechtenstein based on documents the government had received from Germany.
The political pressure to release those names was immense. I mean, everybody wanted to know who was hiding money. But the Supreme Court, acting as the ultimate guardian of constitutional rights, sided with privacy.
Really, even with all that pressure?
Yeah, and their logic was rigorous. They acknowledged the public interest in catching tax evaders. However, they pointed out that merely having a foreign bank account is not inherently illegal. Many people have them for legitimate business or personal reasons.
Right, like if your kids are studying abroad.
Exactly. To indiscriminately publish a list of names without first establishing through a legal process that those specific individuals had committed a crime would be a massive, unjustified violation of the privacy of the innocent account holders. The state cannot strip away privacy based on a blanket assumption of guilt.
Makes sense. Now, the final case in this application phase is arguably the most socially significant, and that is Naz Foundation v. Government of India. This dealt directly with Section 377 of the Indian Penal Code, an archaic law that criminalized homosexual acts.
When the Delhi High Court initially struck down Section 377, they rooted their decision deeply in the jurisprudence of privacy that we've been discussing. They elevated privacy far beyond just, keeping the police away. The court articulated that sexual intimacy is a vital, core facet of human existence.
It's part of who you are.
Yes, a person's sexual preference is intimate to their identity. Therefore, the liberty protected under Article 21 guarantees an individual the right to conduct their private, consensual relationships without the state criminalizing their very existence.
But the government's counter-argument here, and this is the crux of the legal philosophy, the government essentially argued, we are a democracy. The vast majority of the public views homosexuality as immoral. Therefore, the state has a compelling interest to enforce the moral will of the majority by keeping this law in place.
And the High Court's rejection of that argument introduces one of the most important concepts in constitutional law, something you absolutely must remember: the distinction between public morality and constitutional morality.
Okay, let's underline that. Public versus constitutional morality.
The court stated that fundamental rights are not subject to a popularity contest. It doesn't matter if 99% of the population holds a certain moral view. If that view violates the dignity, equality, and liberty guaranteed to every single citizen by the Constitution, then that public morality is completely irrelevant.
So the Constitution is the ultimate shield.
Exactly. The state can only restrict rights based on constitutional morality. Majoritarian sentiment cannot be used as a weapon to obliterate the private sphere of a minority.
It perfectly illustrates that the Constitution is inherently a counter-majoritarian document. It exists to protect the one against the many. So, up until this point in our journey, the entire narrative of privacy law has been defensive. It's been about citizens building higher and higher walls to keep the state out of their bedrooms, their bank accounts, and their minds. But the digital age forces a massive narrative shift. What happens when you actually want the state to know who you are? What happens when the state needs to identify you to give you a food subsidy or a pension or a passport?
This creates the fundamental tension of the modern era. A functioning, modern welfare state requires a reliable way to identify its citizens. But, historically, the Indian public viewed any state-sponsored identification scheme with deep systemic mistrust.
Let's trace the history of this identity crisis, because it's really a story of different government departments trying to solve different problems and constantly failing.
The earliest major attempt was back in 1993. T.N. Seshan, the formidable chief election commissioner, wanted to clean up the electoral process. He pushed for a mandatory, robust voter ID card system to eliminate rampant voter fraud and impersonation.
Which sounds like a great idea on paper.
On paper, yes. However, the project hit a massive wall. the reality of India's porous borders. It proved nearly impossible for local officials to accurately distinguish between legitimate citizens and illegal immigrants. The project stalled out because the data collection just couldn't be trusted.
Then the motivation shifted from elections to national security. After the Kargil War in 1999, the government, led by figures like L.K. Advani, became acutely focused on intelligence gathering. They pushed for a multi-purpose national identity card, arguing that a unified database was essential to track potential threats and secure the nation.
But that initiative also faced resistance and logistical nightmares. It wasn't until 2004, under the UPA government, that a new, undeniable motivation emerged, and that was economic welfare.
Following the money.
Always. The government was spending billions on subsidies for the poor food rations, kerosene, employment schemes, but massive amounts of that money were being siphoned off by corrupt middlemen and ghost beneficiaries. They needed a foolproof way to ensure that subsidies were delivered directly to the actual living human being who needed them.
And this convergence of need security and targeted welfare led to the creation of the Unique Identification Authority of India, the UIDAI, and the birth of the Aadhaar project. Now, Aadhaar was a technological marvel, right?
It really was. It aimed to give a unique 12-digit number to over 1 billion people, backed by biometric data, fingerprints, and iris scans to ensure absolute deduplication. You could not fake an Aadhaar card because you could not fake your own retinas.
But the very success of the technology created the ultimate privacy nightmare. The original plan was to collect just 16 basic fields of data. But then we encounter a phenomenon called mission creep.
Oh, massive mission creep. Because Aadhaar was a huge, unprecedented logistical exercise, every other government department looked at it and saw an opportunity. They realized they could just piggyback on the UIDAI's infrastructure. Soon, demands grew to link Aadhaar to bank accounts, mobile phone numbers, tax records, medical history, religious affiliation, and caste certificates.
And this massive centralization of data leads us to the climax of this era, the case that changed everything. The Puttaswamy judgment. What was the core underlying fear that drove citizens to challenge Aadhaar in the Supreme Court?
The core fear is a concept known as the mosaic theory of data. The petitioners weren't just afraid of giving the government their fingerprint. A fingerprint on its own tells you very little. The fear was the state's newly acquired ability to use the Aadhaar number as a master key to unlock and connect previously isolated databases.
So if they have your Aadhaar number, they can pull a tile from the tax database, a tile from the travel database, a tile from the medical database, and a tile from the telecom database.
Exactly. When you assemble all those seemingly innocuous tiles, you suddenly have a high-resolution 360-degree mosaic of a citizen's entire life. You know where they sleep, what they eat, who they call, what diseases they have, and where they travel. The state could construct a comprehensive surveillance profile with the click of a button without ever needing a warrant or a physical wiretap.
That is terrifying. The courtroom battle in Puttaswamy was epic. Senior counsel Shan Devan, representing the petitioners, pointed out the reality. The data of over 90% of the Indian population was already sitting in a centralized database, vulnerable to state surveillance and commercial exploitation by third parties. He argued that forcing citizens to part with their biometrics to access basic food subsidies was essentially holding their survival hostage to their privacy.
It was a powerful argument. On the other side, Advocate General Mukul Rohatgi vehemently defended the project. He argued that the data was strictly siloed. The tax department couldn't just casually browse the medical database. More importantly, he highlighted the undeniable social utility. Aadhaar had revolutionized the distribution of welfare, eliminating millions of fake accounts in schemes like MNREGA and the public distribution system, saving the exchequer billions of rupees.
Now, the Puttaswamy judgment is hundreds of pages long, and we won't dissect every single paragraph today. But we need to understand its functional impact on the legal landscape we're exploring today. For your exams, what is the key takeaway?
Puttaswamy is the bridge between the analog past and the digital future. The Supreme Court decisively ruled, ending decades of debate, that the right to privacy is a fundamental right, an intrinsic part of Article 21.
Finally codified.
Yes, but they went much further. By acknowledging the staggering scale and unique threats of modern digital data processing, the court essentially declared that relying on old constitutional principles and piecemeal court rulings was no longer sufficient. The state could no longer just not interfere. It had a positive obligation to protect its citizens' data. Puttaswamy birthed the absolute urgent necessity for India to draft a modern, comprehensive, statutory data protection code.
It set the stage for the DPDP Act, which we'll get into. But before we look at how the government tries to protect your data, we have to pivot our focus entirely. Because the state isn't the only entity that can destroy your life in the digital age. We have to talk about how citizens attack each other. We are moving into the realm of digital defamation.
And this is where the legal map truly disintegrates. But let's build the foundation first. Defamation, in its simplest legal definition, occurs when a person publishes a statement that damages another identifiable person's reputation, lowering them in the estimation of right-thinking members of society. Historically, English law, which influenced much of the world, split this tort into two distinct categories: libel and slander.
I think the easiest way to visualize the difference is to think about the medium. Slander is like writing an insult in the sand on a beach. It's spoken, it's transient. The wind and the tide wash it away quickly. The damage is limited to whoever happened to be standing on the beach at that exact moment. Libel, on the other hand, is carving that insult into a stone monument in the center of town. It's written, it's recorded, it's permanent. Anyone can walk by and read it for decades.
That analogy perfectly captures why the law historically treated libel much more severely. A written defamatory statement has a far greater capacity to cause enduring reputational and financial harm than a passing spoken rumor.
But the internet takes that distinction and shatters it. Because I sit in my living room, turn on my webcam, and speak defamatory words on a live stream. Am I writing in the sand or carving in stone?
You are carving in stone. The internet turns almost all speech into libel. The law recognized this technological shift quite early. In the UK, Section 166 of the Broadcasting Act of 1990 declared that words spoken in any program shall be treated as publication in a permanent form. Furthermore, Section 201 expanded the definition of program service to include the transmission of sounds or images via a telecommunication system.
So, because the internet fundamentally works by caching, recording, and storing data on servers, even a fleeting spoken insult on a digital platform is legally treated as a permanent written record. It is libel. Remember that. Slander is spoken smoke, libel is the locked-in log. Now, if you find yourself accused of publishing libel, the law does provide shields. There are 4 primary defenses you can raise to avoid liability. And these were heavily refined by the UK Defamation Act of 2013 to better suit modern communication.
Let's break down the mechanics of these 4 defenses. Defense number 1 is truth. Under common law, this was known as justification, but Section 2 of the 2013 Act simplified it. It remains the most potent defense. If what you said is true, it doesn't matter how much it damaged the person's reputation, you cannot be held liable. The law does not protect a false reputation.
But proving absolute, 100% granular truth in a courtroom is notoriously difficult. Do I have to prove every single syllable I wrote was factually flawless?
No, and this is a vital nuance for your exam. The law requires you to show that the imputation conveyed by the statement is substantially true. A classic application of this is the case of Chase v. News Group newspapers. The court established that you only need to prove the essential core, or the sting, of the statement.
What does the sting mean in practice?
For example, if you publish an article claiming a CEO embezzled $100,000 on a Monday and bought a sports car, but the court finds they actually embezzled $95,000 on a Tuesday and bought a luxury watch, the minor factual errors don't defeat the defense. The sting of the statement that the CEO is a thief who stole company funds for personal gain is substantially true. The defense holds.
Okay, defense number 2, honest opinion.
Formerly known as fair comment. This defense acknowledges that society needs open debate and criticism. It protects statements that are clearly presented as a person's subjective opinion rather than a statement of objective, verifiable fact. However, it's not a free pass to hurl insults. You must satisfy strict mechanical conditions.
What are the conditions?
First, the statement must be immediately recognizable to the average reader as an opinion. Second, you must indicate, either generally or specifically, the factual basis of that opinion. You cannot simply tweet, "John is a complete fraud." You have to provide the context. Having reviewed John's latest financial disclosures and the massive discrepancies in his accounting, in my opinion, he is a fraud.
You have to show your work. You have to give the reader the facts so they can judge for themselves whether your opinion is valid.
Furthermore, an honest, unbiased person must have been capable of holding that opinion based on those available facts. And crucially, this defense can be entirely defeated if the claimant can prove that you were driven by malice, that you didn't actually hold that opinion honestly, but were just using it as a weapon due to a long-standing personal vendetta.
Defense number 3, public interest.
This evolved from the common law Reynolds defense, which originated in a case involving the former Irish Prime Minister. It centers on the concept of responsible journalism. Now codified under Section 4 of the 2013 Act, it protects publishers whether they are major newspapers or independent bloggers who publish potentially defamatory statements because they genuinely believe the publication was in the public interest. Crucially, they must also demonstrate that they acted reasonably and responsibly in gathering and verifying that information before hitting publish. You can't just publish an unverified rumor because the topic is juicy.
And the final defense, number 4, privilege.
Privilege recognizes that in certain highly specific contexts, the need for absolute freedom of speech outweighs an individual's right to reputation. Sections 6 and 7 of the Act define these contexts. Absolute privilege applies to situations like judicial proceedings or debates on the floor of Parliament. If a senator makes a wildly defamatory claim about you during a legislative debate, you cannot sue them, nor can you sue the journalists who provide a fair and accurate report of that debate.
And there's qualified privilege too, right?
Yes, qualified privilege extends a similar, though slightly weaker, protection to fair reports of public meetings on matters of public concern.
And the 2013 Act added a very specific shield for the academic world, didn't it? Peer-reviewed privilege.
Yes. Section 6 protects academic or scientific statements published in independently peer-reviewed journals. This was introduced to stop powerful corporations from using the threat of ruinous libel lawsuits to suppress legitimate scientific debate and critical research.
Here's where it gets really interesting. So we have defined the weapon libel, and we have defined the shields, the defenses. But now we have to look at the battlefield. And this is where the internet causes the entire legal system to short-circuit. We are talking about the geography of the internet. The core legal principle for torts like defamation is lex loci delicti, the law of the place where the tort occurred. But how do you pinpoint where a digital tort occurs when it is uploaded in one country, stored in another, and downloaded in 100 more simultaneously?
The early attempts by the courts to answer this question created absolute chaos. We can look at a sequence of defining cases from before the 2013 reforms to see how bad it got.
Let's start with Berezovsky v. Forbes.
Oh, the facts of this case read like a spy novel. Boris Berezovsky was a highly influential Russian oligarch, deeply connected to the Russian political establishment, living and operating primarily in Russia. Forbes, an American magazine, published a scathing article essentially labeling him the godfather of the Kremlin, alleging deep ties to the Russian mafia and involvement in murder. Berezovsky decided to sue for libel. But he didn't sue in Russia, where he lived and where the political events took place. And he didn't sue in the United States, where Forbes was headquartered and where the article was written and printed. He chose to sue Forbes in the United Kingdom.
And Forbes obviously fought this. They pointed to the sheer math of their circulation. They sold hundreds of thousands of copies in the U.S. They sold exactly 19 copies in Russia. And they sold roughly 2,000 copies in the U.K. They argued that bringing the case in London was absurd forum shopping.
But Berezovsky's counter-argument was highly strategic. He argued that he had substantial business interests in London, he traveled there frequently, and his ex-wife and children resided there. Therefore, those 2,000 copies circulating in the UK caused catastrophic damage to his reputation among his specific circle of influence in that jurisdiction.
The House of Lords had to decide the geographic rules of engagement. What was their ruling?
Lord Steyne delivered a ruling that sent shockwaves through the publishing industry. He explicitly rejected the concept of a single global cause of action, the idea that a publisher should only be sued in their home jurisdiction. Instead, he rigidly reaffirmed lex loci delicti. He ruled that the tort of defamation occurs wherever the publication is received and the reputation is damaged. Because Berezovsky suffered reputational harm among his contacts in London, he was perfectly entitled to sue Forbes in the English courts.
That ruling applied to physical magazines. But the terrifying logic of it was immediately copy-pasted onto the early internet in the case of Dow Jones v. Gutnick.
Gutnick is where the global scope of the problem becomes unavoidable. Mr. Gutnick, an Australian businessman, sued Dow Jones over an allegedly defamatory article published on Barron's Online, a U.S.-based digital publication. Gutnick claimed the article ruined his reputation in his home state of Victoria, Australia.
Dow Jones deployed a technological defense. They argued for a single publication theory based on physical hardware. They said, our servers are located in New Jersey. We uploaded the data in New Jersey. The publication happened in America. Therefore, New Jersey law must apply.
The High Court of Australia fundamentally rejected that technological argument. They focused on the human element of publication. They ruled that digital content is not published when it is passively sitting on a server. It is published at the exact moment and location where a human being accesses it, downloads it, and comprehends it. Because subscribers sitting in Victoria downloaded the article onto their screens, the publication legally occurred in Victoria.
Consider the implications of that logic for a moment, especially if you're taking an exam on this. It essentially established the multiple publication rule for the digital age. If you publish a blog post today and it is downloaded by readers in 150 different countries, you have just committed 150 separate acts of publication. You could theoretically be dragged into court in every single one of those jurisdictions simultaneously, navigating 150 different sets of defamation laws. It's an impossible legal exposure.
And that exposure was compounded infinitely by the element of time, as demonstrated in Lipchansky v. Times.
The Archives case. This one defies common sense. Dr. Lipchansky sued the Times newspaper over articles that were sitting in their digital archives. Now, the standard limitation period for defamation is 1 year. You must file your lawsuit within 12 months of the article being published, otherwise the claim expires.
But Lipchansky's legal team weaponized the multiple publication rule. They argued that because every single download constitutes a fresh publication, every time a new user searched the archive and clicked on that old article, a brand new tort was committed. Therefore, the 1-year limitation clock restarted with every single click.
A newspaper could be sued for a story they broke a decade ago, just because a university student happened to read it for a research paper today. The archive essentially becomes an unexploded landmine with an infinite lifespan.
The court, strictly following the logic of the time, agreed with Lipchansky. They upheld the multiple publication rule, ruling that digital archives were ongoing sources of continuous legal liability.
This combination of rulings, Borowski, Gutnick, and Lipchansky, turned London into the global capital of libel tourism. Rich, powerful individuals from all over the world realized they could bypass the strong free speech protections of the U.S. or the corrupt courts of their home nations and drag their critics into the highly claimant-friendly courts of the U.K. We saw absurd scenarios, like in King v. Lewis, where a U.S. boxing promoter sued another U.S. citizen over comments made on a U.S.-based website entirely in the U.K. courts, simply because a few boxing fans in England might have read it.
This situation became untenable. It was creating a massive chilling effect on global journalism and free speech. The UK Parliament had to intervene. They passed the Defamation Act of 2013 specifically to dismantle this machinery of abuse.
Let's examine the statutory fixes. How did they stop the libel tourists from forum shopping?
They enacted Section 9, a targeted jurisdictional shield. It explicitly addresses non-EU claimants. It states that if you live outside the EU, you can no longer just show up in London claiming a few people read a website. You must meet a stringent new test. You must prove to the court that England is clearly the most appropriate place for the action to be heard.
They shifted the burden of proof. You have to prove actual, substantial, localized damage that outweighs the connection to any other country.
Exactly. This legislative intent built upon the judicial reasoning from an earlier, highly pragmatic case, Jamil v. Dow Jones. In Jamil, a claimant sued over an article accessible in the UK. However, discovery revealed that precisely 5 people in the entire UK had actually clicked the link to read it, and 3 of those 5 people were members of the claimant's own legal team.
That's hilarious.
The court shut the case down, ruling that tying up the High Court to litigate a tort read by 2 independent people was a gross abuse of process. Section 9 codifies that demand for proportionality. It forces courts to analyze the genuine center of gravity of the reputational damage.
And what about the Lipchansky problem? How did they defuse the infinite landmines in the digital archives?
They fixed it with Section 8 of the Act, which officially introduced the single publication rule for limitation periods. Section 8 dictates that the 1-year limitation clock begins ticking on the date the material is first published to the public. Subsequent access, downloads, or clicks of that exact same material do not restart the clock. Once the year is up, the archive is safe.
So the law finally caught up with the geography and the timeline of the internet, but it left one massive, unresolved issue. We arrive at intermediary liability. Don't shoot the messenger. If a troll defamed you using a VPN, routing their connection through 3 different countries, and posting under the pseudonym Dark Knight 99, you cannot find them. They are a ghost. So who do you sue to get your reputation back?
You sue the infrastructure. You target the only entities you can physically identify: the internet service provider, the hosting platform, or the search engine. But the legal puzzle is defining the exact moment a technology company transforms from a neutral pipe carrying data into a legally liable publisher of that data.
Let's trace the evolution of the liability trigger. This is another major exam crux. We have to start with the foundational UK case that set the baseline: Godfrey v. Demon Internet.
Dr. Godfrey discovered a highly defamatory forged post about himself circulating on a public Usenet newsgroup. This newsgroup was hosted by Demon Internet, an ISP. Dr. Godfrey sent a formal notice to Demon Internet informing them of the libel and demanding they remove the post from their servers.
And Demon Internet made a catastrophic legal decision. They ignored the notice and refused to take it down.
The court analyzed this under Section 1 of the Defamation Act 1996, which was designed to protect passive distributors like a newsstand selling a magazine who don't know they are distributing libel. The court ruled that before receiving the notice, Demon Internet was indeed a passive, innocent host. However, the exact second Dr. Godfrey's notice arrived, their status changed. They gained actual knowledge of the defamatory content.
So by choosing to leave it up, they became liable.
By actively choosing to leave it up, they transitioned from a passive conduit to an active participant in the publication. The legal equation established here is absolute. Actual knowledge plus a refusal to act equals liability.
Compare that active failure to the absolute passivity seen in Bunt v. Tilley.
In Bunt, the claimant tried to go after the very bedrock of the internet infrastructure. He sued the ISPs that merely provided the physical internet connection to the trolls who defamed him. Justice Eadie dismissed this aggressively. He ruled that a passive ISP, a mere conduit, simply providing the electronic pipes for data to flow through, is not a publisher. To be held liable, an entity must have some knowing involvement or control over the process of publication. Providing the phone line doesn't make you responsible for the crank call.
What about algorithms? Search engines pull in snippets of text from all over the web. In Metropolitan International School's LTD v. Designtechnica, someone sued Google because defamatory snippets were automatically populating in the search results when their name was queried.
The court examined the mechanics of Google's search engine. They noted that it is an automated processing system operating at an unimaginable scale. There is no human editor reviewing those snippets before they appear. The court ruled that an automated algorithm functioning without human intervention or editorial control does not make the operator a publisher. Google was shielded.
But that shield drops the moment they switch from algorithms to hosting user content, as we saw in Tamiz v. Google.
Tamiz involved defamatory content hosted on Blogger, a platform wholly owned by Google. Initially, as a mere host providing a platform for independent bloggers, Google was not considered a publisher. But the claimant sent Google a detailed notice outlining the defamatory material. Google's legal department took over 5 weeks to process the complaint and remove the blog.
5 weeks is an eternity on the internet.
Exactly. The Court of Appeal ruled that while providing a platform isn't publication, failing to act within a reasonable time frame after receiving actual notice can indeed trigger liability. They reaffirmed the Godfrey principle. Notice demands action.
This tension between passivity and activity is the core philosophy behind the EU e-commerce directive safe harbors, which heavily influence global intermediary law.
The directives provide a very clear framework. Article 12 provides a safe harbor for mere conduits, the ISPs just transmitting the data. Article 13 protects caching, the temporary automatic storage that makes the internet fast. And Article 14 protects hosting platforms that store user-generated content, provided they do not have actual knowledge of illegal activity.
But there is a massive trapdoor built into these safe harbors. It's called the active role doctrine, established in cases like Google France and refined in L'Oreal v. eBay.
The L'Oreal case is the perfect illustration. eBay was hosting listings for counterfeit perfumes. If they had merely been a passive bulletin board, they might have been protected under Article 14. But eBay didn't just host the listings. They actively helped the sellers optimize their keywords, they promoted the counterfeit listings in search engine ads, and they actively shaped the presentation of the content to maximize sales.
They were actively involved in selling it.
Yes, and the European Court of Justice ruled that this level of curation is fatal to the defense. The moment you play an active role in shaping, promoting, or optimizing content, you forfeit your neutral hosting immunity.
The golden rule for platforms is neutrality equals safe harbor. An active role equals liability. But let's ask the practical question. What if the victim doesn't want to sue the platform? What if they just want to drag the anonymous troll out of the shadows and sue them directly?
The legal mechanism for that unmasking is called a Norrish Pharmacal Order. It is a specific court order that compels an innocent third party, like an ISP or a social media platform, to reveal the identity of an anonymous user who is alleged to have committed a tort.
We see this used successfully in Keith Smith v. Williams. Tracy Williams was posting under a pseudonym on a Yahoo discussion group, viciously attacking a politician, calling him a Nazi and a deviant. The politician obtained a Norwich Pharmacal Order, forced Yahoo to hand over the IP logs, traced the IP back to Williams, unmasked her, and successfully sued her for massive damages.
However, courts are acutely aware of the chilling effect these orders can have on free speech and privacy. They don't hand them out on demand. It requires a delicate balancing act, perfectly demonstrated in the Sheffield Wednesday Football Club v. Hargreaves case.
The facts here are very common in the digital age. A group of anonymous fans were on a forum, aggressively criticizing the football club's management. The club's wealthy owners, feeling defamed, applied for an order to unmask every single user who had posted negative comments.
The judge had to weigh the club's right to protect its corporate reputation against the fans' fundamental right to privacy and anonymous free expression. The judge meticulously reviewed the forum posts. He found that the vast majority of the comments, while angry and insulting, were just standard fan banter and hyperbole. For those users, the judge refused the order. Their right to privacy prevailed.
But they did unmask some of them, right?
Yes. The judge identified 4 specific users who had gone beyond banter. They had posted concrete allegations of serious financial dishonesty and criminal greed by the management. For those 4 individuals, the judge ruled that the severity of the reputational damage outweighed the right to anonymity, and he ordered the platform to reveal their IP addresses. It's a surgical application of the law.
So we've navigated the constitutional origins of privacy and the messy common law battleground of digital defamation. Which brings us to the final major piece of the puzzle, the modern statutory shield. We've seen that relying on judges to build protections case by case is slow and unpredictable. How does modern legislation step in to impose order on this massive data economy? Let's look at India's trajectory.
India's first serious attempt to codify data protection came with the Information Technology Rules of 2011. These rules were a good initial step, but they were narrow. They applied specifically to body corporates companies that were processing a very specific category of data known as SPDI.
Sensitive personal data or information. Remember the mnemonic for your exam: PFFHBM, passwords, financial data like bank accounts, health data physical and mental, biometrics like fingerprints, and medical records.
If a corporation wanted to collect any of that sensitive data, the 2011 rules stripped away the ambiguity. They mandated that the company must publish a comprehensive privacy policy. More importantly, they required the company to obtain explicit consent in writing, by letter, fax, or email before the collection occurred. They instituted purpose limitation, meaning the data could only be retained for as long as was lawfully necessary to fulfill the stated purpose.
And they provided a mechanism for accountability. If a user felt their data was misused, the company was legally required to appoint a grievance officer who had a statutory deadline of 30 days to resolve the complaint. The rules even established a technical baseline, citing the ISO/OAH 27001 standard as the benchmark for reasonable security practices.
But as the digital economy exploded, the limitations of the 2011 rules became obvious. They only covered corporate entities, and they only protected a narrowly defined list of sensitive data. Following the mandate of the Puttaswamy judgment, India needed a comprehensive economy-wide framework. That arrived with the Digital Personal Data Protection Act of 2023, the DPDP Act.
The DPDP Act is a massive paradigm shift. It rewrites the vocabulary of data rights in India. To understand how it works, you have to understand the specific roles it assigns, because those roles carry heavy legal liabilities. Let's define the cast of characters.
At the center of the act is you, the citizen, the user. In the language of the DPDP Act, you are the data principal. The data belongs to you. You are the principal entity.
And the entity that wants your data: the social media app, the bank, the e-commerce store.
They are defined as the data fiduciary. This term is crucial. By calling them a fiduciary, the law implies a duty of trust and care. The data fiduciary is the entity that determines the purpose and the means of processing your data. They hold the primary legal responsibility and are the ones who face the massive penalties if things go wrong.
But the reality of modern tech is that the fiduciary rarely does all the work themselves. The bank might collect your data, but they use a third-party cloud service like AWS to store it, and another third-party analytics firm to process it. What is their role?
Those third parties are defined as data processors. They process data strictly on behalf of and under the instructions of the data fiduciary. While the processor has security obligations, the DPDP Act ensures that the data principal doesn't have to chase down invisible subcontractors. If a processor leaks the data, the fiduciary is the one held accountable to the principal.
And the Act introduces a completely new, innovative intermediary role to solve a very modern problem: consent fatigue. It creates the role of the consent manager.
Yes. The Act recognizes that users mindlessly click "I agree" to dozens of privacy policies a week because it's too exhausting to manage them all. A consent manager is designed to be an independent, registered intermediary platform. It provides a single, unified dashboard where a data principal can clearly review, manage, and seamlessly withdraw their consent across multiple different fiduciaries simultaneously. It's a technological solution to a legal problem.
Let's talk about the reach of this law. Jurisdiction under Section 3. The Internet obviously ignores national borders. So does the DPDP Act only apply to servers physically sitting in Bangalore or Mumbai?
Absolutely not. It has robust extraterritorial reach. It applies to the processing of digital personal data within the territory of India, naturally. But crucially, it also applies to processing outside of India if that processing is connected to offering goods or services to data principals situated within India. If a startup in Silicon Valley or a gaming company in Seoul is targeting users in Delhi, they must comply with the DPDP Act, regardless of where their servers are located.
Now, the engine that drives the DPDP Act consists of 7 core principles. These aren't just suggestions. They're the legal mandates that govern the entire life cycle of data. Let's explore the logic behind them. The first is consented, lawful, and transparent use.
This is the foundation. A fiduciary cannot process data secretly or through deceptive dark patterns. The consent must be free, specific, informed, and unambiguous.
The second is purpose limitation.
This ends the era of, we'll figure out how to monetize this later. You must specify exactly why you are collecting the data. If you collect my location to deliver a pizza, you cannot later use that location data to target me with political advertising.
The third principle is a radical departure from the Web 2.0 business model: data minimization.
Web 2.0 is about hoarding every conceivable data point. Data minimization mandates that a fiduciary must only collect the absolute minimum amount of data strictly necessary to fulfill the stated purpose. If you are an app that provides flashlight functionality, you have no legal justification to access the user's contacts or microphone.
Makes total sense. The fourth is accuracy. The fiduciary must ensure the data is correct and updated. The fifth is storage limitation. You cannot keep the data forever. Once the purpose is served, or the user withdraws consent, the data must be securely deleted. The sixth requires reasonable security safeguards to prevent breaches. And the seventh is accountability, which the Act enforces through staggering financial penalties for non-compliance rather than criminal jail time.
But here's where the Indian DPDP Act diverges sharply from many global frameworks. It doesn't just impose duties on the massive corporations. Section 15 of the Act imposes specific legal duties on the data principal, the user.
This is a highly controversial feature. As a user, the law says you have a duty not to impersonate others. You have a duty not to suppress material information when providing data for official documents. And most dangerously, you have a duty not to register false or frivolous grievances with the Data Protection Board.
The inclusion of this final duty raises massive alarms among legal scholars and privacy advocates. The intention is to prevent the system from being clogged with malicious or automated complaints. But the chilling effect is profound. Who defines what is frivolous?
Exactly. The power dynamic is already incredibly skewed. You have an individual citizen trying to assert their rights against a trillion-dollar tech giant with an army of lawyers. If that citizen knows that the Data Protection Board could arbitrarily label their complaint frivolous and slap them with a fine, they might simply choose to stay silent. It risks weaponizing the law against the very people it's designed to protect.
To truly evaluate the DPDP Act, we have to place it in a global context. How does it compare to the international gold standard, the EU's General Data Protection Regulation, the GDPR?
Let's start with the positives. The DPDP Act is highly pragmatic. Unlike the rigid, overly prescriptive laws of the past, it relies on broad principles, leaving the specific technical implementations to subordinate rules. This flexibility means the law won't become obsolete the moment a new technology emerges. It also innovatively uses she/her pronouns throughout the legislative text, a deliberate move toward inclusivity. Furthermore, it liberalizes cross-border data flows. Earlier drafts mandated strict data localization, forcing companies to store data exclusively on servers in India. The final act removes that barrier, allowing India to integrate far more seamlessly into the global digital economy.
However, when compared to the GDPR, the protections are noticeably thinner in several key areas. The Indian Act notably lacks a specific codified right to be forgotten, the right to demand search engines delist outdated or embarrassing information about your past. It also lacks data portability, the right to demand a fiduciary package of all your data so you can easily transfer it to a competitor.
And the enforcement mechanism is fundamentally different. The GDPR empowers data protection authorities to be proactive. They can conduct sweeping audits of companies without warning, searching for non-compliance. The Indian DPDP Act, mirroring frameworks like Singapore's BDPA, relies heavily on a complaint-driven model.
This is a major structural weakness. It places the entire burden of enforcement on the data principal. The system assumes that citizens possess the technical literacy to realize their data is being misused and the legal stamina to initiate and follow through with a formal grievance process. Combine this complaint-driven reliance with the threat of fines for frivolous complaints we discussed earlier, and you have an enforcement mechanism that is inherently sluggish.
We also have to look at how it classifies data. China's data security law creates incredibly rigid classifications. Core data, important data, general data, with massive national security protocols attached to each. The Indian DPDP Act, surprisingly, removes the distinction between general personal data and sensitive personal data that existed in the 2011 rules. It treats a breached email address and a breached medical record with the same broad strokes, which many argue severely dilutes the protection for highly vulnerable information.
But the most profound critique of the DPDP Act brings us full circle to the very beginning of our journey, the state exemptions. Section 17 grants the central government extraordinarily broad powers to exempt any government agency from the provisions of the Act on grounds of sovereignty, national security, or maintaining public order.
It's the ultimate paradox. We started this deep dive exploring how the Puttaswamy judgment was born out of a desperate fear of sweeping state surveillance via Aadhaar. The Supreme Court mandated a data protection law to shield the citizen from the state. Yet the resulting legislation essentially gives the state a master key to bypass the rules whenever it cites national security. It perfectly encapsulates the unending tension between the state's desire for absolute visibility and the citizen's fundamental right to an invisible private life.
The law is never static. It is a constant negotiation between the power of the sovereign, the rights of the individual, and the relentless advance of technology.
We have covered an immense amount of conceptual ground today. Let's trace the narrative thread that connects it all before we finish, especially for those of you reviewing for exams.
We began by searching for privacy in a constitutional blueprint that didn't include it. We watched visionary judges like Subbarao and Karak Singh and Matthew and Govin wrestle with originalism until the right to be let alone was definitively anchored in Article 21 by Rajagopal. We saw how courts weighed that right against the right to a healthy life in Sharda and weaponized it against the surveillance state in the landmark Puttaswamy Aadhaar ruling.
Then we watched the internet shatter the analog rules of defamation. We saw how global connectivity turned a passing insult into permanent, multi-jurisdictional libel, leading to the absurdity of the Infinite Archive in Luchansky and the forum shopping of Baraski. We saw the UK Parliament scramble to fix the map of the single publication rule in the 2013 Act.
We dissected the mechanics of intermediary liability, establishing the crucial line between passive, safe harbor conduits like the ISPs and Bunt, and active, liable platforms that ignore takedown notices in cases like Godfrey and Tamiz. And finally, we saw India attempt to wrangle this chaos into a statutory code, defining the duties of fiduciaries and the rights of principals in the DPDP Act of 2023.
It has been an intensive masterclass, and we want to thank you for sticking with us as we pulled apart the machinery of these laws. But before we sign off, we want to leave you with a final provocative thought, a puzzle that the law hasn't even begun to solve yet. We have spent this entire hour analyzing how the legal system attempts to protect your past. The DPDP Act places rules on the data that companies have already collected about your past actions. Defamation law exists to protect the reputation you have already built over years of past behavior. The entire legal framework is backward-looking.
But the technology is no longer backward-looking. With the exponential rise of artificial intelligence and predictive analytics, algorithms are now capable of ingesting your past data to accurately predict your future behaviors. They can predict what products you will buy, which political party you will vote for, your likelihood of developing a specific mental illness, or even your statistical probability of committing a crime.
Consider the implications. Does the DPDP Act or any current defamation framework protect the privacy of the person you haven't even become yet? If an AI system predicts that you will be a low-performing employee 5 years from now based on invisible data patterns, and a company preemptively denies you a job today based on that prediction, has your privacy been violated? Has your future reputation been defamed by a machine before you ever even had the chance to act?
The court spent 60 years deciding if the state could look into your bedroom window. The next 60 years will be spent deciding if algorithms are allowed to look into your future.
Think about that as you close your textbooks, Prep for your exams and navigate the digital footprint of your own life. The borders of the law aren't just shifting across geography anymore. They are beginning to shift across time. Keep diving deep. We will see you next time.